welcome to this webinar. We really appreciate you taking time out today to join us. My name is Ashutosh and I'll be moderating the panel discussion in today's program. The last several years have seen a consistent increase in private equity investments across different industry sectors. And this trend seems to be remaining strong in the present macroeconomic scenario as well, as indicated by the host of announcements regarding new funds and attendant capital raising rounds. While investors and promoters entrust their faith in each other during the course of investment, the contractual framework becomes important and such faith is eroded. We are seeing an increase in the investor-investor disputes and have created this webinar to share some of our learnings with colleagues from the industry. We've broken down today's program into two segments. In the first segment, we will spend 10 minutes understanding the broad context of investor-investor disputes. Suhail will provide the opening remarks, followed by Shyam, who will take us through the short presentation. In the second segment, we will open the floor for the audience Q&A session. This is an interactive session, and while we have received several questions by email, which we will attempt to answer during the panel discussion, there is a chat option on your screen, and you may type in questions at any time during the webinar. Subject to time constraints, we will try and respond to all questions and comments that we receive during the program. I'll start with a quick introduction to the speakers and panelists now. In order to ensure that the discussion focuses on practical aspects, we are joined today by Ashish Wadhwani. He is the managing partner for IVCap Ventures, a leading investor in India. Ashish joins us from IVCap's Singapore offices today. ELP's experts include Suhail Nathani, the managing partner for the firm, as well as Shyam Pandya, Shailesh Poria, and Mitesh Jain, whose practices center on corporate transactions, disputes, and taxation respectively. Without much ado, let me set the ball rolling on this webinar's first segment. Over to you, Suhail.
Thank you, Ashutosh. Let me extend a warm welcome to all the invitees on this webinar, and of course to Ashish from IVCap for joining us.
Thanks very much.
Honestly, when we started planning this webinar, we had not envisaged how timely it would be, and today we are delighted to note that it is very timely given the bunch of burning issues that is facing the investor community. We've had unfortunate press reports on devices of two business people who have, amongst other reasons, listed pressure from investors or lenders on their economic woes. We have seen recent changes in the Companies Act, which have made it far more difficult to discharge your fiduciary obligations, and of course the pressure building through the IBC process, where the liability of independents and directors are now available to sanction from prosecution by the CBI, the Enforcement Directorate, the Serious Fraud Office, and of course this peculiar tool in India where you have airport surprise, where you're about to leave the country and you find that you can't board the flight because somebody has issued no travel alert on you. There is no way of being notified of this earlier. You only find this out when you are at the airport. But we'll deal with all these issues, and without much delay, I'd like to hand over to Shyam, who will run us through a typical PE life cycle with focus on exit rights and director responsibilities and balancing fiduciary responsibilities. Over to you, Shyam.
Thank you. Thanks, Will. Ladies and gentlemen, I think that as part of the typical life cycle and a timeline for a PE transaction, one is fairly familiar with how there are a few key considerations to be looked at, right from the deal sourcing stage until the deal term sheet, the execution of the legal DD, and right up till during the implementation and once the investment is made, and the exit-related timelines. More importantly, when one looks at the contractual rights and obligations, one key consideration that comes along as part of the entire investment process is effectively the post-due diligence and the post-transaction related documentation, where the discussions amongst the investors and the promoters are heavily negotiated on the legal rights and obligations that each of them need to document. Whilst one looks at the pre-investment liabilities in terms of the reps and warranties and the indemnities and things of that sort, what is more relevant in today's scenario is the aspects relating to the post-investment oversight that investors need to be mindful of. So, for example, in the post-investment oversight, one looks at board nomination, the veto rights, and information rights, particularly where these rights are whether they are in tandem with the overall objectives of the business of the company, or are in line with the objectives of how the promoter is trying to drive the business in the company. But when there is a conflict, for example, when the investor tries to or would like to use a veto right to block a particular decision, how does that affect him insofar as his fiduciary responsibilities are concerned as a board member and his responsibilities as a representative of the fund that is concerned? Will some of these exercise of affirmative rights protect the interests of the fund, or whether it will affect this whole concept that is now being proposed to be introduced by the government, whether he will be a fit and proper person if there is certain amount of conduct that is being expected from the directors and persons who are going to be in control and management of the company. One vexed question that often gets asked is what happens when after the entire investment has been made and there is time for exit. How does one actually look at an exit scenario? And whilst as contractual lawyers and deal lawyers, we would try and make sure that the wordings are drafted in a manner that suits the commercial objectives of both the parties. The documentation may seem fairly straightforward, but once it comes into the implementation stage, that's where it becomes more nuanced and a bit tricky. How do these exit timelines get affected? Whether the promoters have flexibility and freedom to conduct an exit? Is there any fetters on the promoters for valuations? Is there a preferred method to do an exit? Is there an exit waterfall? Will investors prefer to do an IPO, or will they prefer to do a strategic sale, or a buyback, drag, or a put option? Of course, ultimately, all of these would get decided in a very peculiar case. But these are broadly the overall exit waterfall as the term goes, in terms of how investors would like to see their exit rights being implemented. And I think the way in which these rights get implemented, and where in our experience, we are seeing some areas where there could be contentions, are relating to forced exits, relating to the ones where I just spoke about veto rights and the fiduciary responsibilities of the investor directors, enforcement of these exit rights, and how do Indian courts and Indian jurisprudence has evolved in the last decade and a half, and whether there are investor blocks in a particular company and attendant issues relating to that. With this, I will hand over to Ashutosh to see if on all the Q&A related aspect of this webinar.
Thank you, Shyam. That was quite informative.